You're laughing.
We want to close the door.
So this is Tuesday, April 22nd. This is Senate Transportation. We are here with Damian and Tucker from Legislative Council to go through their findings on S4. And I might say this is not our first time looking at this bill, and we have taken testimony on it in the past. You're both on. I guess you've done quite a lot of research.
A little.
Sure. So first, good morning, Tucker Anderson, Legislative Council, and
Damian Leonard from the Office of Legislative Counsel.
for the record,
Ta-da.
and I suppose to lay out the agenda of what Damian and I will talk about this morning, we're going to start with just a summary overview, the legislative history that led into the Title IX statutes related to trails as you see them today. Then we'll talk a little bit about some of the questions you asked last time and do an overview of some of the right-of-way questions that came up. We'll move into any new questions that you have, and then we'll bring up some of the options that the committee has moving forward. And with that, I'll note just a few things that I think you're already aware of. The first is that this is not a court and that we're not rendering decisions, and Damian and I are not in official capacities where we can render decisions on disagreements about the current law. So that's something we're going to avoid doing. In our positions, we're going to give you the language of the law and then tee you up for your policy decisions. So with that in mind, what does this branch do? You are the lawmaking branch. You determine what the law will be. And we are going to point out for you what that power means for purposes of S4 and moving forward. Highlight some of the risks, the real risks that may exist here and how you might navigate them. And another thing to remind you of is that in the legislature, this is a long game. This is not the last stop for this bill.
I just have a question on how we're going to proceed. Do you have written material for us?
I have notes that I can absolutely send to the committee for posting. I also have scans of all of the legislative acts that I'll be talking about this morning.
I'm just wondering about how much note taking.
And as far as memos moving forward at the request of the committee can certainly submit those as well.
Thank you.
Yes. So to start with some of the legislative history involved, the last time that I was in, I discussed how the notion and existence of trails really had its origin in 1921 Act 121. That act established trails as a classification for town highways. And under the provisions of Act 121, trails were deemed highways, but were excluded from the requirement regarding the width of highways. Act 121 further authorized the legislative body of the municipality to allow a trail to be enclosed and occupied by the owner of the land during any part of the year, including the ability to install gates or stiles. So this is similar to pent roads. However, this authority was to be issued in writing and recorded with the clerk of the municipality. The act did not specify whether this recording was to be part of the municipality's records or part of the title record associated with the particular properties. None of that is super relevant to what you're going to be considering moving forward, but I wanted to make sure to be thorough before getting to the last section of Act 121, which is material and the contents of which have persisted up to the present day. The last section of Act 121 stated that municipal corporations shall not be liable for the construction, maintenance, or repair of a trail established pursuant to Act 121. And I will underscore that the term that was used here is liable. One of the things that I am sorry to inform you of this morning is that moving forward, the General Assembly used varying terms in these statutes, a little bit inconsistent, and makes it difficult for us to divine on your behalf what some of the intent was with these sections of law. The text of Act 121 was codified into the 1947 revised statutes, but was not subsequently amended until 1967, when one of the sections related to the declassification of town highways to trails stated that municipalities would not be, again, liable for the maintenance or safety of a trail that resulted from the declassification of the town highway. In 1986, Act 269 added a definition for trail and excluded trails from the definition of town highways. And much of what I'm about to move through persists into the statute you have in front of you. Under the provisions of Act 269, town highways were defined as highways exclusively maintained by a town. Town highways over here. New language was added specifying that trails shall not be considered highways and stating that towns shall not be responsible, underscore that word, for any maintenance, including culverts and bridges. So now we have two different terms used in statute, liable and responsible. It is worth noting that this language was added as a subdivision under the classification for Class 4 town highways.
Are questions as we go along better, or it's just a quick little,
go ahead.
so exclusively maintained by towns? I heard that phrase. Okay,
Yes, and I have responses to your questions from last time about the exclusively or cooperatively language that is used in S4.
okay, so that's all I hear.
All right. Some of Act 269's trail provisions were added by the Senate as individual instances of amendment to H 409 of 1985 as it was passed by the House. Unfortunately, the House and Senate journals do not contain notes about other proposed amendments, any debate or explanation of votes related to Act 269. So the official records of the bodies related to this act don't contain any sort of legislative explanation of how the Senate came to these decisions. And for purposes of explaining the legislative history to you, I only looked at those items that were added to the official record of the body. The 23rd instance of amendment struck a clause within Section 1, 19 VSA, Section 310, that contained the following language. Provided, however, that a town shall not be liable for construction, maintenance, or repair of trails. So back to liable. This language was moved to a new subsection C to add a town shall not be liable for construction, maintenance, repair, or safety of trails. So the meaningful amendment there was to add safety to the list of items that a municipality would not be liable for. By removing trails from the definition of town highway, it may be interpreted that the General Assembly eliminated the statutory duty to repair and maintain trails, statutory duty. The General Assembly expressly limited responsibility and liability as alternate terms within the statutes where they're located for the maintenance of trails. However, Act 269 and current law is silent on the issue of whether municipalities have the authority to maintain trails. And that silence is really the issue that the parties to the case and S4 are dealing with here. In the context of other amendments in Act 269, it could be argued that trail amendments were focused on limiting municipal duties and liabilities, but that the General Assembly did not expressly remove existing authority. Could be argued the other way as well. And again, we can't make a judicial determination of what the intent was there within legislative history.
Which raises, and that's kind of the core issue that is underlying a lot of this, is you have litigation that's ongoing. It's currently in the Superior Court. The parties have filed cross motions for summary judgment and finished briefing them. They are thoroughly and well briefed. I've read all of the briefs at this point. The court is basically weighing two arguments. One is that by omitting the language, the legislature made an affirmative choice to take away that authority to maintain. The other is that by omitting the language, the legislature did not make that affirmative choice to take away, because they didn't write something like shall not have authority to maintain, but instead left an implied authority to maintain without the liability for the maintenance. I know that one of the parties you have here in the room has strong opinions in favor of the first. The towns, I believe, have strong opinions in favor of the second. As I said, this is pending litigation. It is the court's place to interpret the statutes. And in this case, this is one of those instances. Very often when we have courts interpret a statute, if we don't like their interpretation, we can just change the statute and move on. And going forward, the interpretation will be such as it is. In this case, if the court finds that it was the intent of the General Assembly in 1986 to take away that right to maintain, as I mentioned last week, what that means is that the towns would be without that right in the bundle of property rights, and that would have reverted to the landowner. Which means that if you take that right from the landowner under both the Vermont and the US Constitutions, the landowner is entitled to compensation. Currently, S4 does not provide a mechanism to provide that compensation. So that's one of the things we're going to flag for you later on, is that if you move forward with this bill in its current form, that you may wish to consider providing a process by which, if the courts determine that municipalities do not have this right, that municipalities could then gain this right through a condemnation proceeding. I do want to flag for you, having prior to my time here, represented parties in condemnation proceedings. They are time consuming, they are very emotional, and they are very expensive. Often neither party is happy with the valuation from the other party, and it's very hard, particularly when you have an interest of a landowner who may have personal attachment to the land, an aesthetic valuation, and a municipality that has limited money and is looking for a purely financial valuation. It is often very hard to come together on a good valuation. There is a procedure set out in statute for that, which would likely need to be updated because it doesn't deal with trails very clearly or well, in my opinion. It does mention trails in 7 different instances, but not in all of the instances. So if you want to move forward with S4, you likely will want to include some updating as to condemning rights around trails, just to make sure that language is crystal clear, as well as crystal clear intent language that expresses an understanding of the pending court case and the fact that this issue is potentially, is unsettled at this point. It's before the courts. In reading the statute, the general feeling that, and I think I can speak for Tucker on this as well, is that when the General Assembly recodified Title 19 in 1986, it was done so in a way that was not entirely consistent, which is not unusual with large recodification projects. There was testimony in the Senate committee, the precursor to this committee at the time, that the landowners, the plaintiffs in that case, are arguing supports the idea that the legislature intended to take away the right to maintain. We have also been admonished by our Supreme Court not to take isolated statements made by legislators in committee and give them too much weight unless they're reflected in a clear statement in the text of the bill or a written report from the committee for clear proceedings on the floor that reflect that it was the will of the whole body and not just the understanding of one legislator.
Which is why you move to journalize remarks, because then the entire body consents to those words from the individual senator being part of the legislative record.
Also why when there's controversy or a potential for misunderstandings in the future, you will catch us often, particularly say there's rulemaking that we put in, and the rulemaking, there's the language behind it is somewhat broad. We would encourage you to adopt intent statements so that it's clear to the future legislature that where some or all of the members who were here back when the law passed are no longer here, and the future legislature doesn't have that context, it can be clear to them what you meant.
Such as what we just did. It would have been very helpful to have a statement of intent in the 1986 Act 269.
Go ahead.
What is recodification of the statute?
So what happens, and we did this with Title VII, I think it was in 2016 or 2017. And Tucker and I actually both worked on that. What happens is periodically you'll get to a point where a title is in a state where it's hard to follow, it's hard to read. My understanding in the case of Title 19 is that sections were scattered all throughout the title. And so beginning, I think in the 1960s, with a report on some of the statutes, there was the beginnings of a movement saying we should really start recodifying and updating this language. There was a 1973 bill. They can be. So what happens is you may combine sections, you may organize them so they make more sense. When we did Title VII, we had licensing statutes that were scattered throughout with many licensing provisions being buried in definitions. And so in order to make it clear for folks who were producing or selling or distributing alcoholic beverages in the state as to what their rights and responsibilities were, we broke out the definitions, the provisions governing how the Department of Liquor and Lottery operates, the licensing provisions, and then within licensing, we broke it down by manufacturing, sale, distribution, and other provisions like that, and then additional permits. So your restaurant can get a permit to sell alcohol outside, things like that. We broke down all of that so it became more clear to someone who's just coming in and saying, I want to open a store that sells wine. What do I have to do? Where do I go? With Title 19, my understanding from looking back at some of the courts that have commented on particularly the 1973 Act, there was a case that looked back at that act in 1999. They commented on testimony from the Agency of Transportation that argued that the purpose of Act 269 was not to attempt to change any of Title 19, but rather to clean it up and recodify it. In other words, we want to reorganize and recodify. That said, in that process, the legislature clearly did change some things, because what happens is you put in a clean bill that's what we call a technical bill, and the legislature says, well, I don't like that language, or this doesn't work, or I had a constituent who has told me that this is problematic, and then you start to address the substance. So recodification typically starts as a technical process and then ends with a mix of technical and substantive changes. And in this case, one of the things we're dealing with the changes from the 1970s and the 1980s was there an intent, particularly in 1986, to take away a substantive right of the towns with respect to maintenance of the trails. There, as I understand it, and based on the language in the statute, there's no argument that municipalities have the right to regulate uses. That's set out in the plain language of the statute. There is an argument about whether they have this right to maintain or whether that right resides with the landowner. And that really is at the heart of this case. and this bill. Because as I stated before, if the court rules in favor of the landowner and finds that the legislature ceded that right back to the underlying landowners, then in the vast majority, if not all cases, because these rights of way are just easements over the land of the underlying landowner, that right would have gone back. And then in order to get the right to maintain back, the municipality would have to then condemn the right and pay compensation for it.
It doesn't matter the order, like if the bill passed and then they made that determination, but since it's the court's determination goes back to 86, it doesn't matter when the legislature passed the law, clarifying what the law meant.
So that gets us into how statutes are construed. Typically, our statutes don't have retroactive effect. So in other words, we can't go back, to the day before the case was filed and say, actually, here's the way the law is. What we can do is say prospectively, going forward, we're creating a process. And we're saying this right is there. And if the town, for example, what you could do is say, right to maintain. And if the town does not have that right, the town may condemn and then explain why you chose that language. And
If
that
we pass the law that they do have the right to maintain, it wouldn't affect any case that's currently pending or filed.
it's not going to affect the outcome of the case. What it may result is a follow-on effect.
Right.
So as it's written right now, if the plaintiffs prevail in that case and the court rules, and then I'm presuming this case is going to be appealed up to the Supreme Court by one side or the other.
Yeah.
And that may be presuming too much, but my presumption is that it will do that. So it's going to be a while before we have a final answer. If we grant that right to maintain, and then the court rules that wasn't, or if we, let me change my language here. If we put that right to maintain in the statute and the court rules that it wasn't there before. So in other words, we've just granted a right rather than clarifying that one existed. So if the court rules in favor of the towns, the language in S4 becomes essentially a clarification. If the court rules in favor of the landowner, the language in S4 becomes granting a new right, at which point
Right.
we've taken a property right away.
And it doesn't matter if it happens before or after the court makes the decision. The timing doesn't matter.
The timing doesn't really matter. What it does affect, though, is that if the court rules in favor of the landowner and you don't have a process in place for compensation, then our recommendation at a minimum is to consider creating a process for any instance when the town does not have that right, and then leaving it so that, and we'd have to think about the best way to word it, but leaving it so that if the court rules that towns do not have that right, we're not presumptively granting that right and forcing towns into the process of paying, but instead requiring them to go through the process of condemning the land. And then if the condemnation is challenged, being able to show that they meet all the requirements, including the necessity requirement for the maintenance. And I think based on what I've read in the briefing, there is some definite argument as to whether it's necessary, because you've heard testimony already that there are landowners who are maintaining these trails without municipalities. And then there are other instances where there are others maintaining the trails. And again, I don't pretend to be an expert on the individual cases here. You've heard testimony from both the towns and the landowner as to how the maintenance occurs. But I think that that's a risk you run if you pass the bill now without any clarification or amendment to the language, is that if the court rules in favor of the landowner, and I think there is a reasonable chance of that, I think there's also a reasonable chance of the court finding in favor of the towns. I think both arguments have compelling pieces to them. And so I don't think that there's one argument that is a clear cut slam dunk, although I imagine the advocates for both sides would disagree with me strongly on that case. I see multiple people on the sides being like, reading this from a neutral standpoint, I don't see, and from having done the look at the statutory history with Tucker, the underlying cases, I don't think there's a clear cut 100% argument here. I also have said this over and over again in this General Assembly. Even when I feel there is a clear cut winner in a case, I always hedge my bets because I can tell you there were plenty of cases when I was litigating where I thought there's a clear cut winner in this case, and the court found something that did not occur to me and ruled on that basis, and ruled the way that I didn't think they would rule, whether it was fully against the side that I thought would be the clear cut winner or some other more nuanced position. So I do want to put that out there. Tucker, you're ready to jump in here.
I was just gonna say that we've skipped to the last item in the agenda because we're so amped up about this, but the summary here is that make the policy choice that you want to make, and there are avenues for this bill for whatever the policy decision is. And if it's the committee's will and desire to add maintenance to these statutes, whether that's clarifying or adding the authority to maintain, there are structures you can put in place to make sure that this can move forward.
Yeah.
And what Damien was describing is essentially a new section with a contingency
Or
stating
multiple new
that,
sections.
yeah, or multiple new sections, adding a contingency that if the authority is deemed to not exist by a court of competent jurisdiction, that municipalities can acquire it through the existing condemnation procedures.
Yeah, but it's worth kind of stepping back for a minute to make sure that, again, as Tucker used the really good description the first time we appeared in front of you of wanting to skip ahead to dessert, which is all of the meaty, juicy legal issues at the end of the road here when it makes more sense.
Juice for dessert.
Yeah, right. Work on the metaphor.
Sorry about that. Skip ahead to dessert. I am picturing an ice cream sundae right now. I don't know about you guys. Perhaps with a hearty brownie at the bottom of it. Anyway, it is worth getting back to some of the sort of basic points here. So I have said that I think in the vast majority, if not all the cases, these trails will be easements. It is worth noting that there are very isolated instances, and I can't point to one in Vermont that I know of, but there are isolated instances around the country of where the municipality possessed the land before they created the right of way, and they hold the right of way in fee simple, although they may have conveyed away the surrounding land. So there are isolated instances of that. I don't think that's the case with any of these trails, but I don't know. So when I hedge my bets on right of way and having to pay this out, there is the possibility that there are roads that have been downgraded to trails that passed over, that were held in fee simple by the municipality, and they just chose that they wanted to stop maintaining it as a class 3 or class 4 road, and they turned it into a trail. Particularly in the case in the court, I don't know what the background on those is, and I think in the vast majority of cases here, because an easement costs less to condemn in most cases, that's what the municipalities hold. So,
Patrick, and then,
So I keep thinking about ancient roads and I hate to go there because I hated it when we talked about it before.
That is.
It's complicated and I get that. What part does that play, if any, in this discussion?
so I think at the end of the day, ancient roads can be thought of as sort of a parallel issue that may have some overlap, but not really on point here. So the reason I say that is with the ancient roads, what we were looking at is these roads that may or may not have been discernible. But there was potentially some evidence that they existed, old maps. I know in some of the work that I did, you could find things like tree lines or evidence of an old track in the woods. What happened with these cases is that there was a period of time of about 10 years where towns were given to identify ancient roads and include them on their highway maps or just discontinue them. And those roads were either turned into trails or they were turned into class 4 roads on the highways. In many cases, they were discontinued by the towns. And at that point, you basically set up a process where after a date certain, anything that had not been mapped by the towns according to the process you set out was effectively discontinued, which allowed people to have certainty about what was on their property. Because what you were running into were, there's one case that was brought to my attention where the right of way for an ancient road literally passed underneath part of a house that was sitting there. So the house was obstructing the ancient road, which creates all sorts of problems if you then order the person to move their house to clear the obstruction.
Well, they didn't find that until they did the title search on the house.
Right. And so the ancient roads, what you may have is some of the legal trails affected by this may have been mapped during the ancient roads process, but that doesn't affect the underlying rights of the town and the litigation over whether the right to maintain lies with the landowner or the town. That's at issue in this case. It just means that some of the trails that could have been mapped then could be subject to the outcome of the case and could be affected by this bill.
So and just quickly note that under 19 VSA section 302A6A, legal trails are separate from unidentified corridors that you're talking about. They are. Statute says that they are not legal trails. And that was even for purpose of all the procedures that Damien was just talking about, legal trails were separated by the General Assembly from that process.
Repeat what you just said again.
Under the statutes governing unidentified corridors, legal trails are separated from unidentified corridors. They are not included in the definition of what an unidentified corridor is. And that was true for the entirety of that act that you all worked on. Trails were kept out of that discussion analysis
Well,
for purposes of determining what is.
We set the process up where if you were going to give up an ancient road in that it could be turned into a trail.
Correct.
Right. And so that's the piece there is you could have an ancient road and then the town could say, we're going to map it and we're going to convert it to a trail at this point. They could also make it a class 4 road, which is subject to slightly different language in the statute, has clear language that mentions maintenance, which under the current statute, there isn't a specific mention of maintenance with respect to trails in the 19 VSA 300s, which respect town roads. There are mentions of the town not being either liable or responsible for construction, maintenance, repair, or safety. So it's worth noting that responsible means that someone is expected or obliged. It involves accountability obligations and duties, or liable, legally accountable, or answerable. And then liable means that someone is bound or obliged in law or equity, responsible, chargeable, answerable. And it often refers to compensation or restitution. But it can also refer to subject to the possibility of having to do something. So in other words, that you can be compelled to do something that you may not wish to do, but that you can be compelled to do it. So there is also, and I would say liable is used clearly. Sometimes it is used in the case of compensation. Other times it's not as clear how it's used in Title 19. And unfortunately with these cases, there's a lot of argument in the cross motions for summary judgment about whether this implies a right to maintain or not. And there's then look to other surrounding statutes that still seem to potentially imply a right to maintain, although again, the parties disagree diametrically on this. And this is part of the issue with the Title 19 recodification, is that there seems to be language here that wasn't clarified as to what the legislature meant. So for example, if we look to, let's see. Let me just find my site here. So if we look to 19 VSA 1105, and this is briefed by the parties again, and they again disagree on this as to whether this implies a right to repair or not.
It was
But it-
19, what?
19 VSA 1105. So, so a person other than the municipality acting with respect to highways under its jurisdiction, who places or causes to be placed an obstruction or encroachment in a public highway or trail so as to hinder or prevent public travel or to injure or impede a person traveling on the highway or trail shall be fined not more than $1,000 plus the actual costs of repairing the damage, and a reasonable attorney's fee to be recovered in a civil action in the name of the town or state. So the town are arguing that this creates an implication that the legislature intended that the legislature didn't intend to take away the right of municipalities to repair the trail because they could recover damages for the cost of repairing. The landowners have argued that that would be reading this too far, and that instead the town could be recovering the cost, but the repair could have been done by someone else. And forgive me if I paraphrased or misparaphrased that, but and so what we have here is, and this gets back to what Tucker and I mentioned earlier about the recodification being potentially somewhat sloppy and not clarifying some of these things. And it's left ambiguity in the statute that has created reason for both sides to argue their position, because there is no clear, affirmative, a municipality may repair a trail. There's also no affirmative, a municipality shall not have authority to repair a trail. That authority shall lie with the landowner. Instead, we have silence, which brings us to Dylan's rule, which is really Tucker's forte. But I see questions building up. So,
Well, I'm gonna let them go and then come back to both of you. So, go ahead, Tucker.
Sure. Dylan's rule is my bag. I do have, as it creates, so may it destroy tattooed on my back. Now,
That's a lot.
Dylan's rule is a judicial gloss that I'm sure you're all aware of on how the authority of municipalities, particularly their legislative authority, is construed by courts. And municipal authority is subject to strict construction based on statutory grants of power. And if all of that was too complicated, think of it as what is given to municipalities typically has to be given in express terms. And most of the cases that we see deal with the delegation of the General Assembly's legislative authority down to its political subdivisions, which is not what is at issue here. What is at issue is whether municipalities, essentially as a creature or agent of the state, have a particular authority. And there are two lines of analysis that go in here. The first line of analysis based on strict construction is whether or not the General Assembly has either expressly granted the authority or at some point snatched that authority away from a municipality. The other line, based on some more recent Supreme Court of Vermont decisions, could be that part of Dillon's rule is that municipal corporations are in fact corporations that hold inherent corporate power, whether or not the General Assembly has expressly granted it. They are capable, for example, of behaving as property owners, just as any other property owner may behave under state law. So that is something that could be considered here and that the parties have briefed and debated as part of this. With the short amount of time here, I could go on for hours about Dillon's rule, and I would be happy to send you all of my various very in the weeds memos about the history of Dillon's rule and delegation of authority to municipal corporations. But I want to continue to come back to the premise, particularly if you are looking to do something in the near future. You should be considering the policy choices you want to make for the bill, and then providing Damien and I with instruction on how to move forward, because we can build you a bill that passes constitutional muster.
You're a little ahead of where you need to be. You need to back up and go a little slower.
Yeah.
And we'll tell you when we're ready to, but go ahead, Andy, and then.
If S4 was to pass as introduced, would there not still be an issue about what making, how that's defined? What does that mean? It gives them the authority to maintain, but then wouldn't you just get an argument about what's the limits of that?
So I think we do have a number of cases going back to through the years over what a municipality's responsibilities are with respect to maintenance and how it may maintain, particularly around class 4 roads where we grant discretion to maintain or not. The courts have upheld, for example, municipalities that have a policy where it is to provide minimal maintenance to the class 4 roads in town, as funds allow.
Right. That makes sense.
And there have also been cases about discriminatory maintenance and so forth and other duties.
But I could just them saying, okay, we can maintain the trail, we just give you authority, and they go and cut the tree that fell down, or they go in and they pave it.
Right. And I think
those are both maintained.
I think you're raising a concern that, again, if you decide to move forward with this bill, and I'm going to say if you decide to move forward, because I don't know if the committee is going to move forward with this bill or if you're going to decide to wait. Right.
There are whole questions here. One is, what do we want? One is, what's the timing behind this, and what makes the most sense in the timing? And personally, for me, what I'm partly listening to, when we weigh in what the timing is probably as important as the other questions at this point. So we've got work to do to figure out all of that.
Right. And realistically on timing, if you move the bill and it gets out of the Senate before we adjourn for the summer, then the bill is going to sit in rules in the House, and it will not go to the House Committee of Jurisdiction until next January, likely. Which means that even if you advance S4, the House would literally have to suspend rules, which I don't imagine is likely, with somewhere between 4 to 8 weeks to go and big questions on education and state budget.
I'm not worried
So,
about the
right.
house. I'm not worried about the process. I'm worried about us feeling comfortable with what the proper thing to do and make a recommendation to our colleagues in the
Right.
Senate first.
I guess my point was that given the timing in the session, because we are after crossover, there may not be
I
a
would say
rush.
to you,
You never,
I would
But,
say
yeah.
to you that, I've been here a long time. And if we were absolutely clear of what we wanted to do and how we wanted to do it, we could find a way. The question really comes down, what do we gain by moving ahead now, versus, you allude to the questions about if a community, if this is considered a taking, all the ramifications that go from that. And part of that comes into the timing and making a decision for us on what we want to do. We need to feel comfortable in this committee and then to go to the floor on what we would do. At that point, yes, it's more difficult at this time, but nothing's impossible. The most important thing is for us to feel comfortable that we're doing the right thing.
Right. So,
I have
What?
another question.
Yeah.
But I don't know when you have.
Well, Wendy had a question too. So either one of you.
But did you want to?
I was just gonna say, I can't get you to that comfort or, tell you when you're comfortable. But
You're here to provide information.
right, from the standpoint of drafting, because of the lack of clarity around this issue of who holds the right to maintain,
Yep.
the bill it's doable. We could probably figure out language on it. But it becomes much more complicated. And when things get more complicated, there's more room for potential issues to crop up in the future. So obviously I cannot take a position one side or the other or advocate for one side or the other, but I do want to flag for you that because of the legal questions that are out there, if you don't do something like delay the effective date, in order to give yourself time to come back, if the court rules in a way that it calls it into question, then the process of drafting the language becomes more complicated. We have to build in process for the potential event outcomes of the court case to ensure that you've set up that process properly so that it'll function smoothly. And so that we don't end up in a position where we put municipalities in a position where they're not ready to be. And also inadvertently taken property rights. Well, not inadvertently, but taken property rights that may not be your intention to take if you're acting on the assumption that the town is going to prevail, and you all are entitled to reach your own conclusions as to how the case is going to come out.
That's what we did the big buck for.
So, yeah, as the fourth grade class that was in here a few weeks ago was saying, that's why they pay you guys so much.
I've got both of you with hands, so either one.
Yeah, so what I heard in the explanation was that unlike other situations, depending on how the court case happened, the decision, if it was a decision that we did not prefer, that we could not easily change the law. There would be consequences. Well,
Yeah,
it wouldn't be, we would just change it and we go back to a different status. We would have to compensate.
Right. If the plaintiffs prevail in the case, then passing S4 as it's written right now would be in a position where the law had taken a property right, and the towns would then need to compensate for that, right? the way the law is set up with other towns is when you,
She's great.
for example, let's say you've got,
No, I understand. about
yeah,
Yeah.
but the way it's set up is that there's a process.
I understand,
has
and I
to
have
go through
just a
for-
suggestion on that, because, which I want to get to in a second, but first, I just want to have just total clarity about what impact our actions could have at this time. It sounds as if, no matter what we do, the court has information. We're not going to change the court's decision
No, and
by what we do now. If we clarify that the state would prefer that municipalities have this authority, that doesn't matter to the court now. Is that accurate?
right, because the court is construing the statute in effect at this time, and the court is looking to see what was done essentially in 1986.
Okay, so that's,
And so that's the thing, we can't go back
Okay.
in 40 years.
I understand.
And-
So that's, I just wanted to, because that
Yeah.
really makes it
And that
limits our
is
options.
given when they make for a decision, we may have to come back to, if it's viewed as a taking,
Yes,
or not a taking, then there's decisions to make. If it's viewed as would be viewed as a taking, we would have to come back and or we could come back and figure out a process.
yeah, but I just wanted to be really clear on that. So this is a question about the 86 folks. Is it possible that they intentionally didn't put in clear parameters because, maybe they thought, oh, this is a really challenging situation. It's going to be different in different places. We're not going to take a side. We're going to let the towns and the property owners hash it out as things happen. But based on the situation, we're going to trust them. Because it sounds like they knew that it was an issue, but
So-
they did not clarify it.
What I've been able to gather from both the briefings and some of the cases around this is that one of the issues that was coming up was question of town budgets and costs of repairing and maintaining these roads, particularly as Vermont's population grew. And old roads that existed were now having the land along them subdivided and sold and new houses built. That, is pretty clear from some of the discussion that was quoted in the plaintiff's briefing and their motion for summary judgment, that your predecessors in 1986 were discussing the issue of municipal costs with the Agency of Transportation. What I don't know from the isolated piece in there and not having had the opportunity to go back to the archives and try to get a transcript of every proceeding on the bill is whether they took that into account. And the committee and then the Senate as a body agreed that they were going to take away that right to maintain, or whether they just decided to be silent on it and say, well, and I think my paraphrasing of the municipality's position is that they were silent on it with the understanding that this was an implied right that existed within right of ways that you could maintain it for the use. And the plaintiff's position is obviously the opposite, that because these are municipalities, they're creatures of state law. If you don't affirmatively grant that right, then you've effectively taken it away. And there's also a canon of construction that says when you change the wording of the law, it's assumed, and listen closely to this, it's assumed that all of you in this room and in this body understand the implications of any change in the language, which is potentially a difficult standard to meet, but it does have consequences to every time there's a change that could have substantive implications. And that is the core, or at the core of the plaintiff's argument, is that they knowingly left that right out, saying this is potentially going to cost towns too much. And we need to protect the finances of our municipalities, which are being overburdened. And we, you are all familiar with the limited resources we have in
Yeah,
this state.
of course, I was,
To this day, it's a never-ending conversation in this building.
All right,
How do we-
but we don't know if it was intentional to either way. It's
I-
possible that they chose to not.
So, yeah, I would say that I have not seen enough in the briefings or the legislative history to convince me one way or the other.
Okay, and, okay,
So,
so then just getting to what this committee should do. My takeaway from you folks is that our options to impact the court case are maybe none, pretty close to none.
yeah,
So I think we need to be prepared as we move forward to be clear on what we want. But it might make sense to decide that once we know what's happened, because especially when we're talking about eminent domain, I see that would be the end goal, but there could be not the goal, but the end product or process.
Mhm.
There could be other things in between that we might want to think about, other like not be simple, but have use. I mean, there's a lot of ways to have property exist. There's a lot of layers to that basically. And so I don't want us to just jump into some sort of eminent domain plan now. I for sure don't want us to do that now. Because we don't have time and it could get complicated and we should be really thoughtful about it. And there are options before you get to eminent domain. We can make those options. I mean, that's a long conversation that we can.
yeah, and I think that requires a level of creative thinking about your options that
Yeah.
we've come up with a few options within the construct of the bill. But they revolve around sort of the basic construct of the bill. And I think what you're talking about is potentially something that would involve a rethinking of the bill. It is also worth noting too, that there are other interests potentially involved here, and I don't want to muddy the waters, but there is also provision for, forgive me, I'm just going to pull up the spot in my notes. So in 19 VSA 775, anytime there's a petition to discontinue a highway, the select board's required to notify Forest, Parks and Recreation. And it allows either the highway or Forest, Parks and Recreation with the approval of this, the select board or the Commissioner of Forest, Parks and Recreation with the approval of the select board to designate a discontinued highway as a trail. And the reason for this is because a lot of these trails lead into state forest, parks and rec properties and provide access to those. That is not the case in the case that's in the court right now, but it does further muddy the waters here as you're thinking about outcomes, about potential impacts there as well. And it doesn't address at all the question of who has the right to maintain. But as you're thinking about this, your potential responses have to not only account for the interest potentially of the municipalities and the landowners, but also entities like Forest, Parks and Recreation, which is the only one I'm aware of in statute that also has an interest in creating trails that maintain access to their properties, which we created in 19 VSA 775.
Part of my question, how far beyond, if we do anything, will it affect any of the rest of what we do? Forest and Parks is there are a number of high visibility trails that the state has.
So we are talking about trails that are legally declared within municipal networks. We are not talking about trails that may be granted by another easement over the land where the agreement was an easement to construct the trail. These are trails that were discontinued town highways are what is at issue in this bill. So it does create additional complications because those forest parks and rec trails that I just mentioned are instances where there is a class 4 highway that accesses a state property that Forest Parks and Rec has jurisdiction over. And then the town no longer wants to maintain it as a class 4 highway and proposes to discontinue it. They have to provide notice to the commissioner. So the commissioner has the opportunity to say, instead of discontinuing it, completely reclassify it as a trail. Does that make sense? In order to maintain that legal access.
Yep.
But it again would potentially lead to, with that section, there are questions about, I don't know the extent to which there are how many existing trails providing that
You're
access.
gonna get it sometime.
Um,
It's not gonna
exist.
happen.
But it's also, when we're talking about prospectively, you can, and this is something we do frequently, you can say, moving forward, the trail would, trails created after X date would include certain rights, trails created before. If the court rules that maintenance is not part of that bundle,
Okay.
then that would need to be condemned in order to get it back.
Okay.
If you want to allow for that, you don't have to allow for that either.
Okay.
And that's, I think, again, the plaintiffs in the case have argued that that's unnecessary. So,
Andy, and then we're gonna wrap up here.
yeah, and I'm sorry that you have about 75 options on the table
No,
right now.
So I still think there's this question of what does it mean to maintain it, and then on the right of way or so if they could maintain it and there's a right of way, and you said earlier that the town can't regulate the uses,
No, the town can,
and
yeah, that's, so that is clearly set out in statute. And that,
they could say only bikes or only walking or only whatever.
yeah, so there's language in the definition of trail, that says that nothing in this section shall be deemed to independently authorize the condemnation of land for recreational purposes, meaning
Yeah,
independently authorize it separate from language that already deals with that, or to affect the authority of selectmen to reasonably regulate the uses of recreational trails. And then,
which I assume the towns are saying that gives them that implied in that is maintaining. I would assume that's what they will say.
so
How could you regulate the use if you couldn't maintain it for that use?
again, I think the parties would
Right,
argue
that's
opposite
one of the-
points that you can regulate use and not have the right to maintain it, and that
You
is,
just wouldn't be able to
Yeah,
be able
and-
to regulate it very well.
yeah, you've heard both sides of that testimony at this point. And I'm gonna let them speak for their points of view at this point. But I think, there are all sorts of questions, and then there is the question which you're raising here, which is if you are going to clarify or create, depending on how the court case comes out, this right to maintain, do you want to clarify what maintenance means? So I think you've raised the concern about, could you pave a 49.5 foot wide strip, which is the 3 rod width of the right of way? And I imagine that would raise a whole host of new issues if you went to that level, but you may want to clarify what maintenance means. But that again is something where that's not going to affect the outcome of the case. And depending on how the case comes out, you may either need prospective language saying from this day forward, and trails created before this day are treated differently, or you may need to create a process for the trails that have been created to date and are subject to the existing law, which is before the court.
I think we have some thinking to do. And, we'll have some questions for you, that will be clear.
And I appreciate your patience and trying to wade through this with us. And I appreciate all the parties in the room who have not jumped in here and
Well, this is our,
countered my points. So,
this is our time to learn.
yeah. So, and I am sure that you have several other parties in the room that want to weigh in on what we
Well,
just said.
we eventually will do that.
If you
And
move
the
forward.
most, for me as chair, the most important thing right now is to make sure that the members of this committee get educated in a way where they feel comfortable making decisions. And as I said, there's timing issues, there's issues of maintenance. There's issues of whether a piece of this is a taking or not. And I think we've got some things to sort out amongst ourselves.
Yeah. Tucker, did we miss anything?
In-depth discussion of rights of way. And,
And you said you had answers to my questions.
Yes.
But you can
Right.
email them.
exclusive or cooperative, I will email it to you.
They're,
And
It's
There-
not,
share it, it's not anything.
they're back here,
Thursday.
Thursday.
part 2.
Great.
And we'll want to talk to both of you about, what that looks like Thursday.
Right. So I think the more guidance we have from you on what you're looking to accomplish, if you decide to move the bill forward, the better we can draft something and then prepare language that the various interested parties on this bill can comment on and critique and identify things that we've overlooked or maybe didn't phrase as articulately as they feel comfortable with.
Okay,
Yeah, I just,
go ahead.
just one follow-up. I am less and less seeing a benefit to working on the bill now.
Mhm.
I see much less benefit than disadvantages. So if that's not accurate, please tell us next time.
That's exactly where my thinking was to
Okay.
go to talk to them about helping us lay out what the advantages of moving
Yes.
ahead now versus what's the disadvantages of us in those, and making that clearer for the committee as the next step.
Perfect. Thank you.
So one thing I want to flag for all of you is that we have to walk a fine line of not advocating for or against the bill. So we can identify risks.
We aren't
And
asking you
so
to
forth.
advocate.
Yeah.
It's our
Right.
job to make
Yeah.
decisions.
And
Right.
either way it goes, it either in both cases, it is making more sense to me to not put additional language in this right now. So you don't have to respond to that now.
Yeah.
That's what I'm,
Your
Okay.
job
Regardless.
is to be our counsel.
Understood. I just want to flag for you that we're going to be walking a very fine line of trying not to advocate for or against, but also provide information for you on what the potential risks and benefits are of each course of action. But you may get more blunt testimony from other parties who
We got.
Okay.
can advocate for and against.
we'll have a net
So,
for you.
This is not the first time we've had.
And I appreciate that.
I've seen issues and, and that. I think this is probably a good time for us to go offline and